So in the Mega Ride series, number 4, when I constructively criticize vaping with Vic, I alluded to the fact that there is a battery issue, that we should be concerned about battery standards, which we should be, especially considering this particular case that I'm going to speak to. Now, this is out of California. It's out of the Riverside Superior Court, so it's on a much lower court. It's in a state court, but nevertheless, it's a very important case, and it's so all I want to show you is that the judgment was on November 5th, 2015. This has been around for a while, and as you can see, the law firm is this right here, and this was the plaintiff, or the party name, as you can see, the plaintiff. Okay, I just wanted to show you that. So complaint status, the judgment was September 30th, 2015, and then also the judgment for November 5th, 2015, which is the main one here. And the date that she filed the lawsuit was on June 10th, 2013. Okay, so let's go to the next document, which is this here. And this was filed by these, see how it is right here, if you could see this here. This is Bentley, this is the law firm, Bentley and Bidart. And remember, that was, I'll just show you real quick. That was the plaintiff right here, the plaintiff, and this is the law firm. So it's relative to that case. So I can show you that it's relative to what I'm about to speak to. Okay. So this is very interesting what they did here. And this is an older case, but I'm sure these types of cases are going to be won, especially on a state level. Normally they don't go into a federal court, but they can, but normally they're just, because they're tort actions, product liability, things of that nature, with a actual business or corporation or company, will wind up in a state court, at least at the very beginning stages. And she had won in this superior court. So as you can see, it was filed on September 18, 2015 in regards to this particular motion here. And Superior Court for the state of California for the county of Riverside. It's Jennifer Rise versus this gentleman here that runs the Vape Cigs, the Tobacco Expo, and then the Vern Car Wash, where she had bought the product from Cortons To Go Corporation and Does One, and Doles 1 through 100, meaning there are many other defendants that are involved that have not been named. And it's the case number RIC 1306769. And this motion is for plaintiff Jennifer Rise bench brief on the admissibility of subsequent changes to packaging to prove product defect. So this is just another motion that they made outside of the complaint and many other motions that were filed with the court. But why I bring this particular motion up is because of it speaks to the issue itself, and that's what I'm going to speak to. So the trial date was September 18th, 2015, and then you have your memorandum of points and authorities and introduction. We'll read just a little bit of this. It's a very short motion, thank goodness. Anyway, it says, although evidence of subsequent remedial measures is normally inadmissible at trial to prove negligence or culpable conduct, that rule has no applicability in the context of strict products liability. Instead, strict products liability is imposed on all business entities within the chain of distribution who manufacture, sell, distribute, or market a faulty product. Negligence and culpable conduct have no bearing in a strict products liability, nullifying the import of Statute 1151. The key here is a manufacturer of, it could be a battery, it could be a vaping device, or whatever have you, can be held, as far as a strict products liability clause, they can, or even statute, I should say, the manufacturer themselves could be held responsible for batteries, for the vaping device, for a charger, for whatever. And this case is a perfect example of it. And then someone who sells, that is the retailer, the distributor, or the person that markets the product even. So here it says, here Jennifer Rise has sued 3 defendants for strict products liability, bringing suit against the distributor, the wholesaler, and the retailer. During discovery, evidence was revealed that demonstrates defendants modified the vape cig product packaging after charger exploded in Ms. Rise's lap. Now, initially, the complaint was about the charger exploding in Ms. Rise's lap. So that's the key to really what this is all about. But then they added this other motion to it because she was, the packaging itself was misleading, did not inform Miss Rise what she needs to do with this charger when she charged the vaping product in her automobile. This evidence is relevant to the action of Ms. Rise intends to introduce it at trial. So this is a pre-trial motion here. Thing is, you got to remember, like it says in the other document, the judgment was for Jennifer Rise. So she won the case. She won the case. And that's what we need to be concerned about. This is just a motion. It's not the judgment of the judge. I could look around for it. I have to go to the Riverside Superior Court to get it, but I didn't want to go through all that hassle. So the point is the judgment was in favor of Ms. Rise, and that's all that needs to be said. In other words, she won the case. So it goes on to say, as the case is based on strict products liability, evidence code 1151 serves as no bar to admission. So meaning they're saying that they can, that this motion ought to be accepted by the court. And California courts have even held that evidence of subsequent remediable measures logically tends to prove the product was defective before the remedial measures were taken. They cite a case anyway. So the factual summary is, on March 21st, 2013, plaintiff Jennifer Rise purchased a Vape Cigs e-hookah e-cigarette starter kit at the Tobacco Expo in Corona, California. The defendants failed to warn of the dangers in the reasonably foreseeable use of the Vape Cigs e-hookah e-cigarette starter kit, including charging its battery in a car. Proceeded to sell Ms. Rise a defectively designed product. Defendants, as you could see, were in the chain of distribution and sale of the Vape Cigs e-hookah e-cigarette starter kit at issue in this case. And she won against all these defendants, by the way, in the chain of distribution and sale of this particular product. Vape Cigs was the distributor, Laverne Car Wash was the wholesaler, and the Tobacco Expo was the retailer seller to Ms. Rise. While reasonably using the product, Rise sustained significant injuries when the Vape Cigs e-hookah e-cigarette starter kit unexpectedly caught fire and disgorged dangerous corrosive chemicals when she attempted to charge it in an automobile, meaning the batteries. She has now sued the 3 defendants on a strict products liability theory. And under California law, all defendants in the chain of distribution of a defective product can be strictly liable. A manufacturer, distributor, or retailer is liable in tort if a defect in the manufacture or design of its product causes injury while the product is being used in a reasonably foreseeable way. And they quote California cases. And then subsequent remedial measures are admissible in strict product liability actions. I don't really have to go into that too much. It says post-accident consumer warnings are also admissible in strict product liability actions, meaning that the consumer warnings, was she informed properly by the retailer? Did the manufacturer put certain warnings on the packaging in order for her to make a reasonable, foreseeable judgment or a decision on to purchase this particular product? Maybe on the packaging, it didn't say anything about, well, you oughtn't charge it in your car or something. Maybe it should have said that. Mainly reasonably foreseeable. Reasonably foreseeable. See, so the defendants were not reasonably foreseeable in these warnings. The rationale of alt, meaning they're quoting a case, applies as clearly to post-accident warnings as it does to subsequent product repairs or improvements. Accordingly, the exclusion, and then you're not going to get into that. So it can be post-accident warnings, meaning after she buys the product and then she gets injured, did the packaging give her the certain warnings? That's why, like the FDA, in regards to hardware, software, or e-liquid bottles, must have 30% warning on there. It not only covers the consumer, but it actually covers the retailer, the wholesaler, distributor, and manufacturer as well. Because you can't say, well, I got addicted to the nicotine in the e-liquid, now I got a habit. You know, well, they told you nicotine is addictive on the 30% requirement, warning requirements that needs to be on this packaging, on the packaging, on vape packaging. So that's pretty much it. But the key here, it's a very simple little motion, but it speaks to the case itself. Is under California law, or any law for that matter, pretty much any law is like this. It's not just California, but because it's in the California Superior Court, they're speaking to the California law. All defendants in the chain of distribution of a defective product can be strictly liable. Manufacturer, distributor, or retailer is liable in tort if a defect in the manufacture or design of its product causes injury while the product is being used in a reasonably foreseeable way. See, so the manufacturer of Samsung batteries, Samsung manufactures these batteries, and they do not put on their batteries certain warning requirements. They can get their ass screwed, excuse my language, they can get nailed on it, regardless if they say it's for e-cigarettes or not. Even if they say it's not to be used for e-cigarettes, it doesn't not let them off the hook. They are still on the hook. They are still on the hook. Because, like I said in another video, we'll pick on Samsung. There's Sony and many others, but we'll pick on Samsung. Samsung will distribute certain certain batteries to certain distributors. Some distributors will be about automobiles. Some distributors will be laptops. And then some distributors be for vapor products. Samsung knows that they are selling their batteries to a distributor that deals strictly with vaping products, or dealing strictly with laptops, or dealing strictly with car batteries, or whatever have you. And that, through that chain of distribution, if the battery is defective or doesn't have these quote-unquote reasonably foreseeable warnings on these particular batteries, Samsung can be held on a strict product liability tort. What's the word for it? Oh man, sometimes I just lose the words. I guess premise, I guess. But anyway, they could be held liable under the strict liabilities product tort action at all, simply because they did not reasonably foreseeable or reasonably foresee that when the Samsung manufacturer sells the battery to the distributor in regards to vaping products, and then the distributor sells it to the wholesaler, and the wholesaler sells it to the retailer, and then the consumer gets the product through that entire chain of distribution. If the battery is defective, wasn't tested properly, should not have been used a certain way, like in this particular case, she had used it in her car. She had charged this particular e-cigarette starter kit in her car when she shouldn't have done that. But it had nothing was on the packaging that stated otherwise. So she did it and got blown up by doing it. And not only that, it was the dangerous corrosive chemicals that came out of the batteries that caused serious injury on Jennifer Rise. Or I should say to Jennifer Rise. So as you could see, a lot of people say, well, the manufacturer can't be held responsible for a defective battery or defective vaping product or whatever have you. Yes, they can in a state court. And they have multi-jurisdictions, so they can actually, even if they're over in China, they could sue them in a federal court in regards to anyone in China. So if Jennifer Rise wanted to sue the manufacturer of the product, they could certainly have sued whatever Chinese manufacturer they wanted to, or any manufacturer around the world, in a federal court. That's usually where that, this situation would fall into. But she just had sued the distributor, retailer, and wholesaler, which was positioned in their actual physical domains were actually in America. But if she went after the manufacturer of the product, probably was a Chinese product, she could have very well had sued the Chinese manufacturer of this particular product in federal court. So this is a very, I don't want to make this too long, but yes, a manufacturer can be held legally responsible in a court of law for a defective product, or for a product that does not have warnings on there that state that, this is what you should do, what you shouldn't do with this particular battery. And that's the reason why the FDA is going to have battery standards, because the standards will say this is what the manufacturer must put on the box or must put on the battery before they can sell it to the distributor, to the wholesaler, to the retailer, and then to the consumer. And on that point, you guys have a good one. Bye.